Good afternoon, everyone, and thank you for joining us. I'm going to give it just one more minute for attendees to trickle in. Wonderful. We'll let people trickle in, but for the sake of time, I definitely want to get started. My name is Iman Awad, and I serve as the National Director of Policy and Advocacy at Engage Foundation. We're grateful to have all of you with us for today's conversation on the future of voting rights and fair representation following the Supreme Court's recent Louisiana versus Calais decision. As states across our country begin responding to this ruling, important questions are emerging about representation, political power, and most importantly, the future of the Voting Rights Act. Today, we're joined by an incredible group of leaders and advocates who will help us unpack what this decision means, what they're seeing on the ground, and how communities can stay informed and empowered moving forward. Thank you all for joining us this afternoon. And without further ado, I'd love to introduce Representative Don Beyer, a fierce advocate for voting rights, and who also represents the district that I live in. So thank you so much, Representative, for being with us.
Iman, thank you very much. And please vote for me. Uh,
Definitely. Um,
and thanks so much for, I really appreciate Engage's interest and willingness to address this, especially because the Calais decision was mostly thought about as, the legacy African American folks, the slaves, the children and grandchildren of slaves. But it's much more than that because there's also the new Americans who are all over our country. As everyone knows, we have a growing, very quickly growing Muslim population of all kinds of different colors, by the way. So not they don't fit neatly into the Voting Rights Act. But with the Voting Rights Act, the Supreme Court decision ultimately is going to affect everybody who has ever been disadvantaged in the society, who's not like me, an older white male. I come from Virginia. Well, in the years of my childhood, you needed to be an older white male that owned property to be able basically to vote. And that's not an exaggeration. The Byrd machine was based on 10% voter pre representation, not the 50, 60, or 100% we'd love to see.
That's actually an excellent segue into our first question for you. I know we've been focused a lot on what this decision means for the southern states, but we've been seeing a lot of activity, especially in Virginia, with the recent election, the ballot initiative, and then the Supreme Court case. And would love to understand how you see this ruling affecting redistricting and representation in places like Virginia, Northern Virginia, which you represent.
Yeah, in Virginia, I don't see it affecting us very much. For example, we have two black representatives right now, Bobby Scott and Jennifer McClellan, both of whom have very established vote getting propensity in majority white districts. Bobby was elected to the state house and the state senate in majority white districts. And the like, both of them were quite willing to go below the 40% threshold of the Voting Rights Act. Um, and Virginia, despite being the capital of both capitals of the Confederacy, the home of massive resistance, we have the last four statewide elections, we've elected a black Democrat, a black Republican, and a black Democrat to statewide office. So I don't think it affects us that much. We had this a very contentious $100 million battle over trying to politically gerrymander Virginia in response to what Donald Trump had done in Texas, was doing in Florida right now, North Carolina, Ohio, Missouri, and the like. But where I really see the impact, though, is in the southern states below us, from North Carolina, South Carolina, all the way through Texas.
Thank you. One thing we've been discussing too is that Congress does have the power to strengthen voting rights protection. And we've seen efforts like the John Lewis Voting Rights Advancement Act, something you've consistently supported, have faced significant challenges in recent years. Looking ahead, how do you see the role for Congress in responding to this kind of a ruling, and what opportunities exist to protect fair representation ahead of 2026 midterm elections?
There's 4 or 5 strands. Let me go down to the most dominant one. When we were in charge those 4 years, the majority party gets the first 10 bills, HR 1 through 10, and usually HR 1 is your most important bill. For us, both in both sessions, it was the basically the John Lewis Voting Rights Act. That we wanted to strengthen our democracy by minimizing the impact of cash, of money, the super PACs, the Citizens United decision, and making it abundantly clear that we wanted to make voting as easy as possible for people. My wonderful friend, Senator Tim Kaine, has sadly pointed out that too often in the last 20 years, the primary difference between Democrats and Republicans is Democrats want as many people to vote as possible. Republicans want as few people to vote as possible. So we will, when we come back, we very much hope 22 weeks from today to take back the House. Our number one priority will once again be saving and developing and preserving our democracy. So John Lewis Voting Rights Act. Iman, to one, I think, important point, at least in my own political evolution, I've gone back and forth on the filibuster many times over the years. I love the idea of bipartisanship and working together. But it's really clear to me now that as divided as the country is, with the filibuster, we are never going to fix Social Security, the debt, immigration reform, fix voting rights. And that if we look at our history, the filibuster has mostly been used to hold back progressive ideas, primarily historically civil rights. One of the big differences between Democrats and Republicans is we are trying to make the world a better place progressively. They're trying to keep it the way it is. They're conservatives, and conservatives don't like change. Well, if we want change that's moving forward, we have to get rid of the 60 vote margin. Because with the 60 vote margin, John Lewis's act will probably never happen.
No, thank you. Thank you so much for mentioning that. I think for many of us on the call and our experts who are going to be on the next panel, we can express our frustration too with seeing things just kind of getting held up with these rules. But going back to Virginia specifically, having navigated your own complex territory with independent commissions, and then again, the ballot initiative that came this year, are there any lessons from Virginia that you think should be highlighted, lessons, warnings, for other states who are facing similar challenges for the redistricting?
Yeah, one of the things, man, that I very much hope we could do. I know it's naive of me, but this race to the bottom, I think has inspired a hatred for gerrymandering in many, many people across the political spectrum. Wouldn't it be wonderful to actually have a federal non-gerrymandering law? Virginia is one of the states that voluntarily gave it up with the citizen referendum back in 2021. So the district that I represent now is very ungerrymandered. It's classic communities of interest and natural geography and natural political grounds, which is why in a purple state like Virginia, it's 6 Democrats and 5 Republicans. It's very ungerrymandered and it's fair. I mean, it was going to be fair what we did too because of what happened nationally. If we could do that everywhere, it'd basically be the same Democrats, the same number of Republicans, maybe a few more Democrats, but more than anything else, people would feel like they were casting the vote in a fair way rather than some of the ugly things that have happened, for example, in Texas and North Carolina recently. There are a number of really interesting initiatives out there. I've been a fan for a long time of the Fair Representation Act, which is multi-member districts and ranked choice voting, which elects many more people of color, many more women, allows the people to have spoiler candidates so they can vote for that person they know might not win because their second choice can elevate to become their first choice. And wherever we see that happen, we see people running for the middle rather than just trying to win their own primary. In so many seats, including mine, in a non-gerrymandered place, whoever wins the primary is going to win the general. And that sadly has a tendency in both parties to pull people away from where the American people are.
Thank you. And on that note, many Americans, particularly community of colors who have been impacted by these decisions for this ruling, feel like this is another institutional setback and a long struggle for equal and fair representation. I like how much you said fair. This is really about fairness. What would you say directly to somebody who is questioning whether their participation in democracy still matters?
That I understand their frustration and I understand their despair, but I would ask them to take a step back, or two steps back, or three steps back. We have, and I don't want to sound like John Roberts here because I hate what he has done to the Voting Rights Act, and I hate much of his leadership on the Supreme Court. But we have come a long way. In 1974, when we had the Watergate babies take over, there were nine African Americans in the U.S. House. Today, there are 56. We've had a black president. We're now on our third black governor, with Wes Moore. We're getting ever more Muslims elected to positions of responsibility all across the country, including a couple in Congress, and more to come, and many more running. And I'm seeing, there are Muslims in the Virginia General Assembly. That was unthinkable 20 years ago. So I think history is uneven. It isn't a smooth upward path. We're going to have downturns, and we just have to, there's old Chinese saying, fall down five times, get up six. We just got to get back up again and keep at it. And one day we'll get rid of Citizens United, and one way we'll get rid of some of the money in politics. And hopefully we can have an ever greater number of people actually participating in the vote.
Excellent. And for our last question, because it's been challenging, there's been a lot of things that have happened that I know have left people feel uneasy, but I like to try to leave folks on a note both of urgency, but also hope. And you've just been a consistent champion throughout your career on voting rights and democratic reform. Looking back at your record, where do you feel the most progress has been made? And looking forward, where do you see the most urgency and hope?
I am, I guess, most excited about the expansion of mail-in voting over the last number of years. We had, even I was overseas for a couple of years, and so my children away at college or overseas had to go through the process of first, one letter to go ask for the absentee ballot, and then another. It was a two or three step process, and you had to have a reason to vote. And now you have states like California, Colorado, I think Oregon, Washington, I'm sure exactly which ones, who are even Utah, who does abundant, some states mail ballots to every registered voter. And that's a way to get a lot better voter participation. Virginia, I believe, has the earliest early vote represent in the country right now, which is great. Our primary is August 4th. By June 28th, ballots will go out, and then as candidates, we so-called chase ballots. We try to make sure if you got mailed an absentee ballot, Iman, please send it in. We're going to knock on your door every day. It's a way to make it much easier to participate.
Well, Virginia's done an excellent job. I was a former Maryland resident, and my polling place went from having to drive 20 minutes out of the way to being able to walk next door. So I appreciate the ease of access in Northern Virginia.
And we've all seen in really important elections, think Obama in 2008, the long, long lines, having to keep polling places open way past the shutting hour. And the absentee voting makes the mail-in makes it much easier.
Excellent. Well, thank you so much, Representative Beyer, not only for the work that you continue to do in Congress to represent all of us, but for your time today. We really appreciate it. And please consider our community always a resource to you.
I love your community. I'm very proud of you. Thanks for being great Americans
Thank
and
you.
making all this happen. Thanks,
Excellent.
man.
Thank you so much. With that, it's my pleasure to jump into our second portion, which is going to be our panel. We're delighted to have from Common Cause Omar Noor-El-Deen, who works on the legislative policy and litigation work specifically on voting rights, fair representation, anti-corruption, and civil liberties issues at the federal and state levels. So no easy feat. That's a long title that you guys are working on. We have Veronica Worms, a staff attorney on voting rights from Texas Civil Rights Project. Before joining TCRP, she was at the Mann Family Foundation Legal Fellow for Voting Rights Program and heavily contributed to its election protections program. And lastly, we are glad to have Sarah Whittington, who is the Advocacy Director for ACLU Louisiana. So where everything kind of has sparked this conversation, thank you so much for joining us. Her recent accomplishments include overseeing the ACLU's Louisiana's advocacy against subsequently withdrawn proposed ordinances permitting the New Orleans Police Department to adopt real-time facial recognition surveillance. So thank you for all of your work that you're doing. And with that, we're going to go into our first question to you, Omar. From your perspective, what are the broader national implications of the Supreme Court's Louisiana versus Calais decision beyond Louisiana itself?
Sure. Thank you, man, and thank you for Engage Foundation for putting this on. I think it's important to talk about the Calais decision in the context of some other Supreme Court decisions, including the Shelby County case from 2012, 2013, and the Common Cause v. Rucho case from 2019. Shelby County was a case that the Supreme Court struck down Section 5 of the Voting Rights Act. And Section 5 of the Voting Rights Act was what's called the pre-clearance section. So under the Voting Rights Act, states and other jurisdictions, local jurisdictions that had a history of discrimination, before they could change their voting laws, before they could change their voting districts, they had to get pre-cleared by the Justice Department or a federal court. And that law transformed the ability of Black people in America to be able to vote. And then other communities, benefited as well. It was, the thing that brought America the closest to a multiracial democracy than any other piece of legislation beforehand. 2012, 2013, that litigation, the Supreme Court struck down that provision. And what we saw almost immediately after that was a flurry of state and local laws that had the effect of making it harder for Black people, Latino communities, Asian American communities, and other communities to be able to vote. Then in 2019, we had the Common Cause v. Rucho case, in which Common Cause tried to challenge the idea of partisan gerrymandering. And in that case, the Supreme Court said, well, partisan gerrymandering is kind of bad for democracy. But we, the Supreme Court, in this instance, this is too complicated for courts to handle and understand what is too much partisan gerrymandering. Partisanship is just inherent in the political process, and it's too complicated for us. So we're just going to say we have no role in it. And in very kind of legalistic terms, what they said is it's non-justiciable, meaning that courts can't address that issue, and kind of threw their hands up in the air. And then you come fast forward to Calais, and what Calais says is that in order to win now on a Voting Rights Act claim of race discrimination, you need to be able to show that it was race and not anything else that influenced the way in which voting lines are drawn and how communities vote. They said you need to be able to show an alternative map where the state can achieve its partisan goals. So if a state says we want a partisan goal like they're doing in North Carolina, and we litigated that case where there is now one district that is Democrat, you need to be able to show how the state can achieve that partisan goal and ensure non-discrimination in race. But the fact of the matter is, in the United States, today, because of our history, there's something called racial polarized voting. And different communities vote in blocks because of histories of discrimination and of segregation. And so those two things together make it nearly impossible to prove a Voting Rights Act claim post-Calais. And so you said, what are the broader implications of this? Well, one is Voting Rights Act litigation is going to be increasingly hard, if not impossible. Right? The type of evidence now, they said, we're not going to an intent standard. So you don't need to prove intent, but what they have said you need to prove is basically intent. So they're not being intellectually honest with us, the American people, or with themselves. The second is it gave states who want to engage in extreme partisan gerrymandering a very clear roadmap and basically magic words. So all you have to say is, oh, it's not because of race, it's because of partisanship. And then now courts have, then the Supreme Court said in Common Cause v. Rucho, we can engage in partisanship, in deciding what's too much. And so now states have like a get out of jail free card, go, they don't, Monopoly, like you pass go, you don't go to jail, you just keep on going. Like they have a get out of jail free card. in order to achieve their goals. But this is about race. When you look at the districts that are targeted in Louisiana, in Alabama, in South Carolina, although they failed in the redistricting there, in Mississippi, in North Carolina. In North Carolina, there were 2 Democrat districts post their map draw in 2020 in last fall. One of them was primarily African American district, the other was white. Which of the 2 did they decide to redraw? It was the Black district, not the white district. And what did they do? They split that district, the Black voting age population, in half. 50% point one, 49.9% on the other. So don't, it's disingenuous, it's lying to say that this is just about partisanship and it's not about race. 2 things can be true at the same time, but I think something that gets left out of this conversation in the media conversation around it, which is usually about the horse race, a Democrat's going to win, a Republican's going to win. And it leaves out what communities are actually facing and the racial discrimination that is going to be allowed and is being allowed because of that decision. So what are the long-term impacts across the country? It's a lack of fair representation. We will see a decrease both in Congress, but also in state legislatures across the South, a decimation of Black representation, and in other states, and I'm sure Veronica will talk about this in states like Texas, of Latino and Latinx communities, we'll see it much harder to ensure that we're moving closer to that constitutional promise post-Reconstruction of getting to a multiracial democracy.
No, thank you so much, Omar. I appreciate it. I'm going to hand it off, and apologies, Nikki. I'm joined here from my colleague, policy manager for Engage Foundation Texas, who's going to be co-moderating with me. So take it away, Nilfour. Thank you.
Thanks, Imana. My next question is for Veronica. We're both based in Texas. So our state has long been at the center of national voting rights and redistricting battles. From your perspective, how can the Cali decision further impact communities and representation across the South, including at local levels?
Sure. So, just for context, in Shelby County v. Holder, Shelby County is located where in Texas? And the second that Shelby County v. Holder, as Omar alluded to earlier, was decided, Texas passed a voter ID bill that had previously been blocked by preclearance. So the second that Texas has any license to do something that was previously blocked under the VRA, they tend to do it. What impacts are we going to see across the South? Unfortunately, we're already seeing impacts across the South. The second that the Calais decision came out, a bunch of states rushed to redraw their maps, including Louisiana, including canceling an election and throwing out 42,000 already cast ballots in that election in order to redraw their maps and dilute minority representation and the representation of people of color. I think that unfortunately, we're going to see a lot more of that behavior. One of the things that is really striking, coming from a Texas perspective, is that we just went through a mid-cycle redistricting in 2025, pretty famously. And that decision, those maps were challenged in the 2021 litigation. So for those who aren't aware, our 2021 maps are still in court right now because they are being challenged for violating the VRA and intentional discrimination as well. So even before we've decided whether the 2021 maps are unconstitutional, we passed new maps for 2025. And those maps were brought into the litigation to say, hey, we still haven't figured out whether the 2021 maps are legal. We can't have these 2025 maps enacted now before we've even decided whether 2021 is okay. And a 3-judge panel in the Fifth Circuit, which is one of the most conservative and anti-voter circuits out there, unfortunately, heard all of the evidence, and actually a Trump-appointed judge, district judge, wrote an 160-page opinion saying, yeah, it is very likely that race predominated in this redistricting. And for that reason, we're going to say, Texas, you can't use your 2025 maps. You have to stick with the 2021 version until we figure out what's going on there. That case went up to the Supreme Court. Texas appealed, said, hey, Supreme Court, we still need our maps. And Justice Alito wrote, along with Gorsuch, I believe, a concurrence, but basically they allowed the maps to go into effect. And their reasoning was that it was too close to the election to change the maps at this point, that there was too much reliance on the 2025 maps that, by the way, we hadn't gone through an election under the 2025 maps yet. So everything had to change in order to accommodate these new 2025 maps from 2021. But yeah, 11 months out from the midterm elections was too close to change the maps. And that is really striking because after, that was in December. 4 months later, in April, we get Calais, which completely changes the standard, rewrites the test, as Omar elucidated so beautifully, unfortunately. And there was not one mention of it being too close to the election in the entire opinion. There is a voting rights principle that federal courts use called Purcell, which is basically we can't change the rules too close to the next election. If you control F that entire opinion, there's not one mention of Purcell in Calais, which is just incredibly striking. So the implications at the local level and beyond, I think what we need to take from this as states that are in places that are pretty anti-voter, that are against voters of color having the representation that they deserve. In Texas, for instance, 95% of our population growth was due to voters of color. So it is really striking how much our legislature is committed to diluting that representation. What we're going to see is that the federal government and the federal courts are not necessarily going to save us. I think it is even more important than ever for states and people at the ground level to engage with their state legislatures and to engage at the local level, engage with your county commissioner's court. Forgive me, that is a Texas type local government that not most other states don't use. But whatever seat of local government you have, you can affect real change there. For instance, in El Paso, we have independent redistricting commissions for the county level, right? There are things that we can do at the local level to engage and to ensure that people have representation, but it's going to be a lot more on us and a lot less reliance on federal courts at this point until things change.
Thank you, Veronica. Our next question is over to you, Sarah. Louisiana has unfortunately been at the center of this process. Since session wrapped yesterday, can you walk us through what this has looked like in practice and what has stood out most in how these redistricting efforts moved through this process?
Yeah, thank you so much, Iman. And sorry to everybody watching. I'm really, really sorry. It absolutely is just pretty sucky right now. So I think for us, in practice, what it looked like was multiple hours of hearings over and over and over again. And I think what our legislature allowed was for everyone to come to the table and acknowledge their disagreement with the maps, their opposition to the maps, everything that they thought was wrong with the idea of losing our second opportunity district, and specifically the representative in that seat. And so what it looked like was that our Senate had two separate committee hearings. One that spanned the whole day on a Friday when they're not usually in session, another that started the following Tuesday evening at 7 p.m. and ran until 4:30 in the morning when they passed that map. And so it looked like very long nights and days. But the people showed up and the people made it hurt. They made it hard for these legislators to really have to sit there and listen over and over and over again. And interestingly, there was one card in support of a map that eliminated this opportunity district across the entire session, one card. And so in Louisiana, you submit red cards for support, or excuse me, red cards for opposition, green cards for support, and it was just one. Additionally, and this was very interesting, it was only ever the bill author at the table. So oftentimes you would have on redistricting plans the Secretary of State's office to talk about election practices. You would have the demographer to be there to explain what these districts are and how they were drawn. None of that happened. They relied solely on the bill author senator. And his cell phone because he was clearly getting texts from the governor's office throughout to kind of tell him when and how to explain Calais and why this map supposedly aligned with Calais, because it was pretty clear through probably almost halfway through the process, he had not in fact read the decision. And so his ability to explain it and what it meant was extremely problematic and difficult. And then the other thing that we know is, and just for context, last October, late October, we moved our qualifying dates already. So we thought after the October 15th hearing at the Supreme Court, our legislature went into special session and suddenly got it in their head that they were going to get a decision by December or January at the latest. So they went ahead in October and moved qualifying dates. That decision didn't come and didn't come and didn't come. So when we went into our regular session in March, they pre-filed placeholder bills for all of these maps with the idea that if it dropped at any point during session, they'd be ready to move. That's exactly, unfortunately, what happened. And I think, Veronica, to your point, how we have suddenly abandoned the Purcell doctrine when it works for conservatives, it is the most powerful tool and they shout it from the mountaintops. And then suddenly we had ballots cast in Louisiana for our congressional primaries. And the Secretary of State, with alacrity never before seen in a Secretary of State's office, suspended the election, declared a state of emergency that did not exist, and hung banners everywhere, which led to massive voter confusion. Folks were thinking that the entire election was canceled, not showing up to vote. So there were also really insidious voter suppression tactics around a very important election because it also had a ton of constitutional amendments on our ballot. And then through the rest of session, the other thing that I think really stood out, and that I think has to be named is, and I think Omar made this point very clearly, they previously in all other maps, they would acknowledge our total population from our census, our voting age population, our registered population, and then it would give breakdowns along Democrat, Republican, other, and Black, white, and other. And they just simply cut our race data out so that they can allege that they didn't think about race at all. And the thing with Louisiana that is, I think, interesting and unique is that we have more registered Democrats than Republicans, and we have always had more registered Democrats than Republicans, but it is a little over a third Democrat, a little, right, very close now, Republican, and then a third, almost a third other party. And so I struggle to understand how we listened to hours of testimony about how this was a quote unquote fair partisan map when it is a 5-1 Republican map. And that is not even acknowledging and naming race. And interestingly, when they didn't include race data in the breakdown, it's very easy to get that information and align it from census, and we're able to do so. The other thing that I think is also very concerning to me is that while they alleged that it was a partisan map, they did also spend a significant amount of time trying to talk about how this was not about race. So race was almost said as often and as frequently. And it was sort of that moment of I think you're protesting a little too much here. And if you continue to say it's not about race, your alarm bells should really be going off. But I will say that at least in our experience, and I do know it was different than in other states, we had about 3 weeks left in our session. They gave two very long hearings on the Senate side for a total of almost 15 hours of testimony. We had about 10 hours of testimony on the House side, again, all in opposition. And then on the Senate floor, the bill was actually heard and debated for approximately, I believe, about 3 hours. And on the House side, they actually gave it a full day, allowing members to, go and speak. And so I appreciated at least that they put on the show so that we could all feel like we had said what needed to be said about this extremely unfair map. But the really disheartening part was also that we gave them multiple opportunities to pass alternative fair maps, and they refused. And they fell along lines of saying that, like, a very obviously, contiguous and compact district, quote, didn't pass the eye test. And yet, the district that we're left with is a random snake from Baton Rouge to New Orleans, and that very clearly passes their eye test. So I think we have a lot of Republican members that do need their eyes checked as well, unfortunately. But that's really what our session looked like. And I will say the one other thing that also happened, and this one was, I think, the most concerning part, was that our elections were moved. So when the Secretary of State canceled our elections, it threw basically up in the air what would happen, how would they figure out how to immediately change our laws on our closed party primary systems, our qualifying dates, and everything for our congressional races. All of that happened through what's called a conference committee in Louisiana. So it was a bill that was meant to just be a quote cleanup bill of our election code. It had been objected to. It was sent to conference with 3 people from the House and 3 people from the Senate, meeting behind closed doors, and then coming out and saying, this is the new bill that we've all agreed to, let's pass it. And that happened very, very quickly and behind closed doors, again, without the opportunity in this case for folks to weigh in on the implications and the impacts. And it changed again for folks, aside from voters who had cast their ballots already and had those ballots canceled, or people who did vote that Saturday and had their votes not count, because I could still hit my button and vote for the person, my candidate of choice. So it was just simply not counted. It also has an interesting impact on the candidates who have spent their money and campaigned, and for some no party folks gotten signatures to qualify on these ballots. All of that is erased. And it's concerning to us what that means. And while I very much respect the belief and understanding that I would love to get money out of politics, while it's there and while we know it's there, there's an interesting challenge for folks who are running either in open seats or against incumbents that had already spent a significant amount of money on their campaigns. So.
No, thank you, Sarah, for going over all of that. It's definitely astonishing to hear how fast the rules can change while an election is going on. And it actually goes well into my next question, which is both for you and for Veronica. I guess, Veronica, if you want to speak on this first. So, your organization, For You Texas Civil Rights Project, has been deeply involved in litigation and advocacy around voting rights. I know that TCRP has been counsel on some of the key cases, even like the Petaway case in Texas that changed how redistricting gets analyzed. So, what legal or grassroots strategies do you believe will be most important moving forward now?
So one thing that I think is important to highlight is intentional discrimination is still illegal. Okay, the VRA may have been eviscerated, and what that means is that it's a lot harder to get into court for things that are not necessarily going to win on an intentional discrimination claim. Like, the effects of this map are that it dilutes the representation of people of color. That's a lot harder. But that intentional discrimination bar is still there. It's harder to meet, but it does exist. I think another thing that people tend to overlook sometimes is that the federal courts aren't the only avenue. We have state courts, and there have been a lot of really interesting and novel legal strategies that start in state courts. For instance, we filed a challenge to the Tarrant County redistricting under a Texas constitutional provision theory. We ended up having to discard that because of unfortunate venue and not wanting to create bad law in the area. But there are other avenues that people can try that still exist in the state court. Also, First Amendment claims and First Amendment challenges are another potential avenue. People are getting creative, essentially, in the absence of a reliable VRA. And I think that it's also important to remember, as the representative mentioned earlier, and Iman mentioned earlier, that Congress has the power to check the Supreme Court. That is, in fact, what happened in the 1980s. So, for a little bit of Supreme Court history, in the 1980s, in Mobile v. Bolden, the Supreme Court said, "Hey, the VRA means that you actually need to prove intentional discrimination in order to win on any of your claims." And when that decision came down, Congress said, "Hold on a second, we meant what we said. We want it to be that if you can prove that the effect of this map or the effect of this law is that people of color have less representation, then that's actually the test." And they passed an amendment. And from then on, we had this Jingles framework, which the Supreme Court in Calais rewrote essentially. But it does prove that in a balanced system in our three branches, there is room for Congress to intercede and say, "Hey, Calais is not what we meant to say. You completely misinterpreted what the VRA should be." And we can pass things like the Fair Representation Act or the John Lewis Voting Rights Advancement Act to check those issues. I think it's also going to be really important for us to communicate with folks why redistricting is important in their communities. I think that redistricting gets kind of nebulous and brought out of context. And when you start going into the details, a lot of people's eyes glaze over. I know that mine do sometimes. When you start talking about, see that, all the different little terms that you need to know when you start talking about redistricting. But what it really means is, who's going to have healthcare in your community? Who's going to get funding for that hospital that your community needs? For instance, in East Texas, we have a huge hospital desert in East Texas. And in the most recent session in the 2025 redistricting, we had a congressional district that went from North Austin, which for those who are not in Austin, North Austin has like 3 hospitals. We're lousy with hospitals in the Austin area. And it takes that little sliver and puts it all the way over to East Texas. And that's an entire congressional district. Do you think that the folks in East Texas are going to get the exact same consideration as people that are in North Austin on hospital funding? That's the kind of thing that I think it's helpful to have that context on what the actual effect of these redistricting maps mean. It means that communities of interest, people that have similar backgrounds, similar economic opportunities, that they need to have their representation. And how you get that done in this kind of post-Calais landscape is you need to petition your local governments and showing up at your state legislature. In the statewide redistricting case that we just had in Texas, we had thousands of people show up, even when there weren't even maps to testify on, to talk about how they oppose the redistricting. And so many of those community members that showed up, their testimony showed up in the briefs. It showed up in that 160-page opinion that I talked about earlier. Your voice matters. It really does. And I think that it's important for people to know that, and for people that are in decision-making positions to know that we're watching. I think that one of the things that Calais has illustrated for people is how unfair this process can be. The fact that we are taking for granted that parties, independent of anything else, can just rig the game and that's supposed to be acceptable is pretty unconscionable when you think about it. And I think that drawing attention to that and coming together as our communities of interest is really what's going to turn the tide here eventually. It may be a bit of a slog, but I think that's eventually what's going to get us where we need to be.
Thank you, Veronica. Now, same question, Sarah, as you're an advocacy director at the ACLU. Your organization is deeply involved in litigation and advocacy. What legal or grassroots strategies do you believe will be most important moving forward?
Um, I will leave legal for actual legal experts. I like to say I only play a lawyer at the Capitol, although I'm barred here. But I know Calais is still an open case and it is ongoing. And I think that's something that is extremely concerning for all of us to continue watching. And that is, I think, an inherent unknown that I don't even want to put a guess out there of what may or may not happen within what Calais still is and potentially could continue to be, sort of as like this elephant in the room specifically for us in Louisiana right now. So I think for what we saw at the Capitol, our strategy moving forward is specifically going to be really grassroots based. We were able to mobilize a lot of people, and in that mobilization, we were able to start education around voting rights. Obviously, they've also changed, and we will have to figure out voter IDs. So currently, if you vote with a provisional ballot or you don't have your ID with you, that's fine. And the Secretary of State, it's incumbent on them to determine your voting status. Moving forward, you will have to have a state ID. So I think there's got to be a multi-part strategy and sort of like a broadening of our tent for service providers and for schools, for our churches and our other, religious organizations, our Divine Nine organizations, all of those in New Orleans, all of our social aid and pleasure clubs, all of the community groups that matter and that people will obviously already be engaging with, getting them to be ready to step up and say, did you know in November this is going to be what's true on your ballot? And this is going to be what you need to vote. And this is going to be how you vote. And this is going to be where you vote. Because what we've also seen, unfortunately, is that there has been a really significant expansion and widening of our inactive voter list. So we don't necessarily purge in Louisiana, but if you don't vote for 2 cycles, you will be placed on an inactive list, and it causes barriers when you go to try to vote. And we know, and we're going to need folks to try and basically check now, fix that now, so that they are in a much better place to vote or to be ready to request their absentee ballot. And that it will be, I think, statewide. In the last two constitutional amendment cycles, we've worked and really rallied and organized and educated around constitutional amendments and ballot initiatives that we've been able to defeat in this state. And I think we have to continue building on that success. And quite honestly, right now, a lot of people's disappointment and distrust with what's happening in our state government, and use that to acknowledge and name that, votes will always still matter. Vote, 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 vote. I'm pretty sure it comes from Louisiana, where people were told to vote early and vote often. And that sort of has to be the rallying cry and the support that we're trying to build in our communities right now. And I know it is also just Calais alone. We still are waiting, unfortunately, on our Secretary of State's results from our May 16th election, but we have anecdotal evidence that there was a really significant Black voter turnout. And I think that is directly in response to Calais, that when people felt like something was being taken from them, they're much more likely to be like, wait a second, no, this matters and I'm going to prove it. And the way that we have to make sure folks continue to show up and show out is proving it in our ballot boxes. And so that will be a challenge. It's got to obviously be very relational, and built on a lot of trust in the communities that we will be going into, both urban and rural. And I think for us to making sure that it's not necessarily a partisan issue. End of day, I don't care who you vote for, honestly. It's really just matters most for us that we have folks that are educated and voting. And I think that is where I think we can see the turn, and also then that accountability that we need in our state government, that folks are paying attention.
Thank you, Sarah. Thank you, Veronica. We're coming up on our last 10 minutes, and there are some questions in the chat, but I want to turn back to you, Omar. And I think you've touched on this in your opening remarks that although Calais has upended longstanding precedent, many advocates were not terribly surprised with the outcome. But what surprised you? And was there anything about the decision that you kind of took away? And if we could discuss some of the past developments at SCOTUS in the federal courts or within redistricting trends nationwide more broadly, what's helped set the stage for Calais to happen?
Sure. And actually, I'm going to go outside of the voting context because part, I think, of what's happening here is the Roberts Court and Chief Justice John Roberts himself's project to undermine our multiracial democracy. And so John Roberts believes in something that's called the colorblind Constitution. And so he doesn't see color. Right. And so all of our laws and legal doctrines need to be colorblind. And so we can go all the way back to a case in 2007 called Parents of Community Involved. And in that case, there was a voluntary integration program in a public school system that involved busing. And some parents challenged that, and in a Supreme Court decision, John Roberts said that it was unconstitutional to engage in that sort of integration because he said the best way to stop discriminating on the basis of race is to stop discriminating on the basis of race. And so he doesn't see the difference between remedial measures that are meant to repair or fix past historical discrimination. In John Roberts' view, we start over. We start today. Forget about the past. Forget about American history. We start today. We are in a post-racist era. Is kind of the ethos that these opinions give. And you see something similar in the Harvard admissions case. The students were involved for fair admissions, SFFA v. Harvard and UNC, which had the same ethos of, well, it's unfair to consider race as one of many factors in admissions decisions because, the implication is racism doesn't exist anymore. The effects of racism doesn't affect anymore. Centuries of slavery, those consequences we're not really dealing with anymore. That is what their line of cases are saying. And so Shelby County, Calais are, I think, all a part of this larger project, which is to say we cannot address the systemic and structural barriers that people of color and primarily Black people have faced because of our history of slavery in the United States, of racial discrimination, of Jim Crow. And that is, I think, the project that all these cases are moving us towards. And so in that way, Calais is not all that surprising.
Thank you. And I think that brings us to our last question from Nikki.
Great, thanks, Amanda. So this question is for everyone. We'll do Veronica first, Sarah second, and then we'll close with Omar. So as these fights continue in courts and state legislatures across the country, we want to end with hope. What gives you hope right now?
What gives me hope right now is how engaged people are. I think that one of the only silver linings, really, of this most recent volley of voting rights decisions is that the game is up, right? I think that it's pretty clear to people what's going on here, that they are essentially trying to launder racial discrimination under the guise of being colorblind. And that's really apparent in these recent decisions. But people are paying attention. People are showing up. They're getting more involved. I've gotten more and more calls from people that want to be involved in our election protection work here in Texas, people that want to testify, people that want to help other voters navigate our insane election code in Texas. Lots of lawyers that want to be involved. I think the saving grace of this is that I think it's woken people up to the fact that the civil rights movement isn't just something that happened in the 60s and not something that we have responsibility for anymore. The civil rights movement never ended, guys. And we need to really pick it up and keep running with the ball, is what I think this has shown me. And I'm encouraged by how many people seem to be game to do that.
No, thank you for that, Sarah.
Yes, ditto everything Veronica said. And I think for me specifically, what I'm going to hold is in one of our hearings, early in the hearing, we heard from Dr. Leona Tate, who was actually one of the New Orleans Four that desegregated New Orleans schools, walked through the screaming crowds of white supremacists, and basically sat at that table and told those state legislators, like, you are walking all of this back. Like, do not do this. And her testimony was extremely powerful. And then later in the same hearing, we also heard from a young man named Josiah Hardy, whose name, if it isn't already like everywhere soon, it should be. Because he basically, and I think in this maybe probably wasn't activated. He's clearly already someone who is paying very much attention and is very well aware and is involved. And this actually gave him the opportunity to be seen for everything he's already doing. And so we had sort of this like, maybe it's sort of the like passing of the torch type moment in our hearing to see one of our elders who is still motivated to show up is not, I don't know how, totally burnt out and exhausted yet. And then also a very, very young person who sees from and can stand on those shoulders and continue to carry that torch and now has a place to be seen and recognized and acknowledged for all that he will be able to do in the very, very many years that he has ahead of him. So that's actually really where I just get to sit in my middle-aged middleness and hope that both that the young can really continue to move us.
Oh, that's beautiful. Thank you for sharing that. It's gonna take all of us. It's a good reminder. Last, Omar, what's giving you hope right now?
I think what's giving me hope is that these outcomes are not inevitable. And so we saw in Indiana a grassroots movement that was cross-ideological that stopped them from their mid-decade redistricting. That would have been a blow to fair representation. We saw the same happen in South Carolina. And that's because people are making choices, right? They're making choices every day to fight for our multiracial democracy that we aspire to. And so folks are paying attention. And it's like those of us here on this call and around the country that are helping create the conditions for everyday people to make sure that their wants, needs, and desires are heard by those in power.
Great, thank you. Like, truly, we should always remember that people power is, it may sound hackneyed at this point, but people power is truly like always so important. And, with interest to the people, we're going to turn to audience questions now so that we can hear from the folks who joined this call. We know we heard from Representative Don Beyer about what Congress can do, and we've had this question: how likely is it that Congress will overrule the Supreme Court, and what conditions are needed for this to happen? I guess overrule, Callie. Not sure who wants to take this question. But...
I'll jump in real quick because then I actually have to jump. But I'll say, and this goes back to some of the legislation we talked about earlier. So the John Lewis Voting Rights Advancement Act and the Freedom to Vote Act that were part of what was kind of HR 1 in 2021, the For the People Act, and then got split into different bills. Like those bills were this close to being passed, right? But for a couple of then Democratic senators, Sinema and Manchin, who did not go along with creating a carve out for the filibuster to pass Voting Rights Act, Joe Biden, who was opposed to changing the filibuster, changed his view and then became supportive of a filibuster carved out for voting rights legislation. Two senators stood in the way of kind of what could have been transformational legislation. And so sometimes I think we look back and think like, oh my God, the future is so bleak and we're so far away and it's such a, monumentous hill that we have to climb. And we were that close. And I believe we can be that close again. And I think in my view, both as a hope and a call to action, that this current chaos and mess is a galvanizing force to get us even closer and across the finish line. And Congress does have the power to do this. Without getting too in the weeds, in both Calais and Shelby County, these two Supreme Court cases, those are actually statutory cases. So they talked about the statutory language of the Voting Rights Act, which is Congress's power. They could have, but didn't, made a broader constitutional argument that would have then made it much harder for Congress to act in these instances. And there's theories about why they did that. I think that could have been even a broader galvanizing moment if they would have kind of undermined the Voting Rights Act through a constitutional ground. But that's all to say is that there is work to do, and we were close, and we can get close again, and we can win again. And with that, I'm going to have to jump. Thanks, everyone, and I'll hopefully see all of you soon. Thank you.
Thank you so much, Omar, and for all the work you guys continue to do. We're just a little bit over time, but if I can keep both of you just, there's one more question, and I want to make sure we're informing our community and audience. And how common are voter roll purges in other states? I know this has been a topic and would love for you both to address the question.
I can jump in first. Texas has a very storied history of voter roll purges, unfortunately. One of our more notorious ones was in 2019, where 100,000 people were kicked off the rolls via Secretary of State Whitley under the theory that they were non-citizens. These were pretty much all later found to not be the case. What happened is that they were previously flagged as non-citizens in an old government database, and they later became naturalized citizens. But because they had previously been in some government database listed as a non-citizen, they got flagged even though they were properly registered. So we actually entered into a settlement with the state of Texas, and they are no longer able to do that weak matching that they did to purge so many people or attempt to purge so many people from the voter rolls. But essentially, there's nothing wrong with voter list maintenance, right? Like, people move, people pass away. All of that is very normal. What's suspect and what we're talking about with voter roll purges is when government actors actively try to disenfranchise as many people as possible or flag as many people as possible, especially with really weak data, as we saw in the Whitley purge. So basically saying, okay, there's a John Smith in Galveston County that's a non-citizen, and there's a John Smith in Galveston County that is a naturalized citizen, but we're going to flag both of them because the name John Smith corresponds with both of them. That kind of thing is unfortunately something that we see in a lot of states, but Texas is particularly notorious for it, unfortunately.
Yeah, and I think it's also, we saw it specifically in the first administration that there was a massive increase in these purges. And part of that is also because of, and I think due to Louisiana specifically engaging in the SAVE database. And that database, it's different from the SAVE Act and the Save America Act and all of that. The SAVE database is actually this cobbled together data warehouse at the federal level of inherently bad data. And it's been acknowledged by DHS to be bad data. But our Secretary of State ran everyone's name through that system, again, like what Veronica said, in an attempt to find anyone who might be a non-citizen voter on the rolls. And ultimately, what we then saw is a massive increase in these folks who have been labeled as inactive until they update their information. But specifically, I think this is also a very important thing for the ACLU nationwide and at states where voter purges can happen. And so I know that in Virginia and in North Carolina, in Michigan and in other states, it is not uncommon. And it is often the work leading up to these major elections, midterms and others, where our offices will engage in and ensure that there is not a purge ahead of an election in order ideally to protect that level of voter integrity. But it is very, very state specific. So I think if the question was like, how often does this happen? It always is going to depend on the state. And it's going to be incumbent, unfortunately, on each voter to sort of try and understand when and how people may be purged and then do everything they can to prevent it. Here in Louisiana, unfortunately, we have a parish that's pretty rural. They purged an entire town basically of people because the registrar of voters said that they would not mail it to PO boxes and people didn't have rural route mail delivery. So there was no way for them to confirm an address when literally the state says you have to send it to their address and they said, well, we don't send it to PO boxes. So they're just never going to get their paperwork, right? Like when that happens, that's a significant problem that needs to get fixed. And so folks kind of have to be aware of when and how that might be happening to really push back and be like, this is not okay.
Thank you so much, Sarah. Thank you so much, Veronica. We know it's not easy in the states that you guys are doing the work, so we really appreciate not just your time on this webinar, but also everything you and your organizations continue to do. I did drop in everybody's websites, so please make sure you visit their websites, sign up for their notifications and updates, follow them on their social media accounts. They always have amazing resources. And apologies to those in the audience, we were unable to get to all the questions. We are almost 10 minutes over. We'll be sending a follow-up email that'll provide a link to this webinar as well as resources from all of our organizations. So thank you again. And just as a reminder for all the work that we do, make sure that you pay attention to your primaries and go vote and register. Thank you all.